Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm here to answer your questions on live today on YouTube and Facebook. Thank you for joining us. So feel free to put your questions in the chat in the comment section, and I'll be happy to answer them. I'm here for the next 30 minutes to answer your questions related to employment law. So I'm the senior associate, the managing associate of our Calgary office. So I often talk a lot about what's happening in Alberta. But we're going to start today briefly talking about Ontario. As some of you may know, the Ontario government or the province of Ontario is entering a provincial election in June. And so there are a lot of competing electoral promises being made out there. Just recently, the Ford government, the government that's currently in power, raised the minimum wage to $15 an hour. And just this weekend, the Liberal candidate, Del Duca, promised to raise the minimum wage even further, up to $16 an hour. So a lot of things happening in this election for workers in Ontario. Quite a few issues being addressed by both parties, and the NDP has a platform as well. So minimum wage, of course, is one of them. The Ford government has also announced that it will require employers to have a disconnection policy, by which that means that every employer over a certain size will have to have a policy in place stating how it will allow its employees to disconnect. Especially important since the pandemic, with so many people working from home. There's been a bit of a bleed between work life and family life. It'll be important to see how this fleshes out and what enforcement mechanisms are in place to ensure that after the workday is done, employees are allowed to disconnect and spend time with their families or on their own, rather than responding to emails or attending, to work matters. So something to follow up on, and we'll be keeping you abreast of those developments in the coming months. We talk a lot about these kinds of developments on our show here on our live Q&A session, and also we have a blog on our website, which is employmentlawyer.ca. Employmentlawyer.ca has a lot of information on developments in the law, in the Employment Standards Act, recent court decisions that have come into work, and it just a lot of answers to a lot of the most commonly asked questions that we get. So if you have any questions, you can't make it to the show, you can't make it to the live Q&A, jump on our website. You'll probably find the answer to what you're looking for there. So we have a question from Lou on YouTube. So she seems to be on she's a non-union and is on a leave of absence. If I'm called back and I don't want to return to that job, will it be too late to claim severance when they call me back if I haven't done it before? Can I claim severance when they call me back? So it's a bit of a tricky situation. So essentially, if you've been placed on a leave of absence and you're not okay with it, it's important that you raise your hand about the issue quickly. If you simply are okay to be on a leave of absence, then there could be a finding that you consented to the leave of absence. So if you consent to the leave of absence, then you can't thereafter claim constructive dismissal and go after your severance. So if you haven't been called back to work yet, it's important you contact us so that we can protect your right to go after severance. A lot of these of people who have been placed on a leave of absence due to not being vaccinated are being called back to work as restrictions are loosening. So if you're interested in going after your severance, it's important to get in touch with us sooner rather than later. If you wait too long, if you wait until you're called back, or if you wait until you actually return to work, then your right to go after severance might, vaporize. So it's important to get in touch with us so we can give you, the right time of day on what your rights are and how to enforce those rights moving forward. Janine Savoie Elson asks, "Hi, Luc. Back in December, I went on an unpaid leave with an oil company. Am I owed severance? They asked me to go back, and I've decided not to go back. So to follow up on the question that we just answered here, you may still be owed severance. There's particular ways of dealing with this. So essentially, you could say, I don't know how long you've been there, Janine, and all of that, but imagine you've been there 15 years and you are owed, let's just use a number, 15 months of severance for being placed on leave of absence, but then you're called back to work after 4 months. So the employer is going to argue, they're going to try to argue at least, that, to the judge, for instance, sure, judge, Janine is entitled to 15 months of severance, but she could have gone back to work after 4 months and therefore should only be entitled to receive 4 months of severance. Because after the 4 months, she could have gone back to work, earned a salary, she'd have no losses. So there are ways to deal with that argument. It's important to have an experienced employment lawyer by your side to go through that process. But essentially, that's the employer's position is going to be, well, you're only owed severance till the time we called you back. So if you're interested in going after that severance or even more severance, get in touch with us. We can help you get your severance package. Now, I use the number of 15 months. It could be that it's more or less. You're able to calculate your own severance entitlements very easily on our website. So pocketemploymentlawyer.ca is a site that we have that has a severance calculator tool. It asks you 4 easy questions, and you'll get an estimate of what your likely severance entitlements will be. It's a free service. No questions asked. If you just want to get some information, you're thinking about what your options are, or you're just curious, jump on there, get to know what your severance entitlements are. And like that, you'll have an idea of what kind of compensation we're looking at. It can be quite substantial. It can be up to 24 months of severance. So definitely jump on there, take a look at what you might be entitled to. Speeches Beyond asks, hello, sir. I was dealing with a bully at work who was being protected by my boss. I was fired for complaining by email about harassment. How many witness statements do I need to win my case? So there's no real amount of witnesses that you need to win your case when you're claiming constructive dismissal based on a poisoned work environment. In fact, you might have enough right here just by the fact that you complained, all right, that you raised your hand and said, I'm the victim of bullying at work, employer, do something about it. Now, when that happens, the best course of action is to contact either HR or your immediate manager. Put it in writing as you did, Speeches Beyond, always the best thing to do. Don't just tell someone. It's important to put it in writing so that there's a trace of you having said this later on. So if you were terminated because you raised your hand and said, I'm the victim of workplace violence, whether you were actually the victim of workplace violence is secondary now. The fact that you raised your hand and they retaliated against you for trying to enforce your right to be free from workplace harassment and violence is enough for you to be entitled to a severance package, potentially even more. All right. So workplace violence and workplace harassment are forbidden under the Health and Safety Act, especially in Alberta and Ontario and at the federal level. So what happens is if you ask your employer to protect you from workplace violence and workplace harassment, and they instead retaliate against you and fire you for having made a complaint, you now have a claim under the Health and Safety Act to reprisal. You also have a claim for having been terminated for discriminatory reasons, essentially under or retaliatory reasons under the Health and Safety Act, and also at common law. So you can go after your full severance. In some cases, your entitlements under the Health and Safety Act may actually be greater than your full severance entitlements. So, and this is without even considering whether you had a strong claim to workplace harassment, all right, which you may also have, in which case, again, always important to try to put some of this in writing if you can. So keep a log of what's happened. For instance, I tell my clients if they contact me and they feel they're being harassed at work and it's an ongoing issue, when you get home that day, write down the details of the incident with as many details as possible as to what was said, what happened, who was there, what time it happened. What started it, what ended it, really. You're trying to get the W-5 there, so that when you are dealing with this a year or two down the line, you have an aid, a memory aid, to remind you of exactly what happened. Because of course our memories are fleeting, right? You might forget all the details of what happened when it happened. But if you wrote it down, contemporaneously to the incident, then you'll have all the information you need to remember what happened there. But all that to say, speeches beyond, is you might already have enough to win your case. All right. So it's important you contact us, reach out to us. You can visit our website to schedule a time to speak with our intake team. We're at employmentlawyers.ca. That's employmentlawyers.ca. Visit the site, learn more about workplace harassment, workplace violence, and enforcing your rights to severance if you're in a toxic work environment. We have a question from Facebook here, from Majid on Facebook. I was with a company for more than 12 years, 5 years full-time, contract, and 7 years permanent. But they calculated my severance according to my permanent years only. Is that correct? So no, it's not correct. All right. So basically, if you want to enforce your severance entitlements, it would be based on your full length of services in 90% of cases. What sometimes happens is that an employer, when you become permanent, will ask you to sign a new employment contract where they explicitly say that they're not recognizing your past years of service. Now, that is more or less legal. It's important that you have an experienced employment lawyer review that contract, if there is such a clause, to ensure that that clause is enforceable. If it isn't enforceable, then you are on a strong footing to say, no, I'm entitled to a severance package calculated on my full year of service, my full years of service. Now, in my experience, you never get the best offer from your employer in the termination letter. That's why a lot of people contact us to negotiate and improve their severance package, and we're very successful in doing that. And we're often successful in doing it very quickly. So it's important you contact us. I don't want you to think that the offer in your severance package is the employer's best offer, or even what you're legally entitled to. So you need to contact us as soon as possible so we can help you get what you're legally entitled to, your best offer, a fair offer, if you're terminated. Angela Straker asks, if I've also been placed on a leave of absence and contacted your office 2 weeks ago by filing in the online form, what is the turnaround time to receive of a reply? Well, I think we're beyond that our turnaround time is better than 2 weeks right now, I got to say, Angela. So I'm curious as to what may have happened if the request did not go through or something like that. I would suggest you reach out to us again. Let us know in your comments that this is the second time that you're reaching out to us. It might be that there was an error on our system or something like that, but usually we're able to get to people a lot quicker than 2 weeks time. There's an email here on the screen for you, help@employmentlawyers.ca. Let us know what happened there. We'll get to the bottom of it, get you set up with someone at our intake office to help you get sorted and get in touch with a lawyer as quickly as possible. Grace asks, I was with a big bank for 10 years as a mortgage advisor and was fired for the realtor's license without any payment. Had any transactions with any brokerage. How do you think of my case? So I'm not exactly sure I understand your case. What I'm understanding from your case is that you didn't get the realtor's license. If the realtor's license is a requirement of your job, and you were contracted on the basis that you would get your realtor's license, then the employer might have a good reason to let you go. However, if you were working as a mortgage advisor for 10 years without a realtor's license, and all of a sudden it became a requirement of the banks, and it wasn't a requirement of the regulator, for instance, then if they terminate you, they can still only terminate you with a severance package. So we would need a bit more details on your case, but I do think you're probably entitled to a severance package if you were able to work as a mortgage broker for 10 years with no problem. So definitely get in touch with us. Employmentlawyers.ca is how you do that. We need to get to the bottom of why you were let go and what the role of your realtor's license had in that, and figure out, get you sorted so that you can get your severance and move on if you were let go for not having the realtor's license. Just need a little bit more detail of what the requirements are to be a mortgage broker or a mortgage advisor, rather, at the bank at the time you were terminated. Once again, my name is Lluc Cerda. I'm a senior associate here at our Calgary office of Samfiru Tumarkin. We're employment lawyers. I'm here to answer your questions for the next 15 minutes. If you have questions, put them in the chat. We'll get to as many of them as possible today so that you can find out what your employment rights are and how to enforce them. I have a question here from Maha Gaib. I hope I pronounced that correctly. Maha asks, am I entitled to severance if I have a termination clause in my contract telling me my employer has a right to terminate my employment? I was working in an industry that usually lays off employees temporarily. So 2 parts to that question. Firstly, are you entitled to severance if there's a termination clause in your employment contract? And secondly, can you treat your layoff as a termination if there's a history of layoffs in your industry? So let's start with the first question, the impact of a termination clause. So severance, when we speak of severance, when we tell you you're entitled to up to 24 months of severance, that's the state of the law right now. However, parties are free to draft a contract clause in a written employment contract that says that you'll be entitled to less severance if you're terminated. We're seeing it more and more. And if the clause is enforceable, you'll be limited to the amount in the clause. All right. So the amount in the clause can be anywhere from about a week per year, sometimes even less, to about a month per year. They can be quite generous sometimes. Rarely. The point of the clause is to reduce the employer's exposure when they terminate you. That said, the clause has to be drafted in a way that is valid. All right, it has to be in compliance with certain laws, including the employment standards statutes in the province of your employment. All right, the problem is employers are notoriously bad at drafting clauses that are enforceable. So you read the clause as an employee, you say, well, black and white, this says I'm only entitled to 4 weeks, I'm only entitled to 8 weeks. Why would I bother an employment lawyer to tell me that the clause says I can only get 8 weeks? 90% of these clauses really are unenforceable. All right. I spend the good part of my day reviewing termination clauses and seeing that they're not drafted correctly. And if they're not drafted correctly, it's as if they don't exist. And that's when you can just go after your regular severance, which, as I said, can be up to 24 months of severance. So if you see a termination clause in your employment contract and you've just been terminated, the first thing you want to do is reach out to us. Go to the website, employmentlawyer.ca, book a consult with us. We'll review the clause. We'll let you know if it's enforceable, and we'll let you know if it's not enforceable, what you are entitled to. So definitely the fact that you have a clause in your contract should not prevent you from reaching out to us. Oftentimes, in my experience, most clauses that I see are unenforceable. Your second question was, if I work in an industry that has a history of layoffs, how does that impact me? So industries that have a history of layoff, for instance, I would say the construction industry. All right, you work in construction, you get laid off come winter time, you get hired back in the spring. All right, now there's 2 scenarios there. All right, you're working regularly, you get laid off in the winter, you get called back in the spring. Can you claim that your layoff in the winter was a constructive dismissal, thereby entitling you to severance? Generally, no, because you've been laid off before. You know you're going to be called back in the spring. You can't go claim that your layoff is a termination, simply because there's an industry practice. You've been laid off before. You haven't objected before. So what's the issue now? That said, imagine you've been working in the construction industry for 15 years. Like clockwork, you're laid off in December, you're hired back in April. This time, April comes around, they don't hire you back. May, they still haven't called you back. June, they haven't called you back. So it looks like they're never going to call you back now. You may still be entitled to severance, even though you've been laid off, and there's a cyclical nature to your job. At some point, if the employment has ended, then you could be entitled to severance. All of these scenarios are kind of fact specific. So you want to reach out to us, speak to us, find out whether you're entitled to severance. All right. So that's one scenario. Another scenario is, although there's not a cyclical nature, there's not a history of layoffs every year. You've been with the company 30 years, right? In 2008, during the financial crisis, you were laid off. You didn't raise your hand. You were like, I'm happy to be on layoff as long as I have a job when I come back. Come COVID, you get laid off again. You get called back from COVID. Now, I don't know, events in the world are, impacting production lines. There's not enough work for you to do. They lay you off again. You've already been laid off twice. You didn't raise your hand at that time that you objected to the layoff. You can't do that now. All right. If, however, others were laid off and you were never laid off, I think you have a case, honestly, that, if this is the first time you've been laid off, no matter what happened to your colleagues, you never agreed that they could lay you off. All right. And then you can go after your severance. Of course, another thing to look at is your employment contract. Your employment contract might say, well, employer reserves the right to lay you off if need be. But if those are absent, essentially the employer has no right to lay you off. All right. People think that, but it's not true. You have to agree to be laid off. Otherwise, it's a constructive dismissal. The first time you're laid off, you can say, no way. If you're not going to provide me work, if you're not going to provide me wages, well, what is that? That's a termination in my view. I'm going after my severance. Absolutely. I have a question here from Steph D. Can you give an example of a non-enforceable termination clause? Well, I'll give you the example that the Supreme Court found was non-enforceable. All right. So this was in a case back in the 90s. Essentially, so what's important to know, for instance, is that under the Employment Standards Code, no matter what happens, if you're terminated, you're owed a certain amount of severance. So for instance, in Alberta, if you've been working for 10 years, no matter what happens, if you're terminated, you're owed 8 weeks of severance. All right. Now, we have employers who have the American mentality in mind, and they'll say employment is at will. What employment at will means is that you can be terminated with no severance. All right. So in that scenario, a termination with no severance is in conflict with the Employment Standards Code that says you may be entitled to up to 8 weeks. So that's an illegal contracting out of the Employment Standards Code. And that's what happened in the Supreme Court of Canada decision. Essentially, the employer had a clause, you can be terminated on 2 weeks' notice. At the time, under the Employment Standards Act of Ontario, that person was entitled to 4 weeks of severance. And so the clause offered less than the minimum guaranteed by the Employment Standards Act at the time. And the Supreme Court said, well, no, you can't do that. And in fact, if you do that, we're not going to assume that you meant the minimum under the Employment Standards Act. We're going to say that clause never existed. So you employee who's been employed for 4 years, who was of a certain age and might be entitled to 8 weeks or 4 months of severance, well, that's what you're entitled to go after now. Instead of 2 weeks, instead of 4 weeks, you can go ahead and fight for a month per year of service, 4 months, which is, 8 times more than the clause provided, right? So this is the kind of numbers we're looking at. It's a lot more. The termination clauses are really trying to limit what you're entitled to. So that's one example. I could probably name 15 or 16 examples of things that I've seen wrong with clauses. I won't go into it. It's very technical. You've heard of, people getting off on a technicality. This is totally it. But the amount of money at stake, the amount of severance at stake can be quite substantial. So this is really something where you don't want to read it yourself and say, oh, this makes sense. I guess I can't find a hole in this. You need to have a lawyer review that, because there are dozens of examples of clauses that have been held to be unenforceable on the most technical of details. So definitely you want to have someone review that. All right. Insight and Senses asks, why are employees being laid off that have chosen not to be vaccinated without a clause in the contract, I guess is what you're asking. What is their recourse? So, I mean, the reason why is more or less relevant. The question really is, what do you want to do about it? All right. So if you've been laid off because you're not vaccinated, you potentially have a claim in constructive dismissal, which is to say, employer, you're not providing me with hours, you're not providing me with work, you're not providing me with wages. That to me looks like I don't have a job anymore. If you're not going to give me a job to do, then pay me my severance. That's a constructive dismissal. So that's the claim that you would have in Sights and Senses, is that you would have a claim in constructive dismissal, which means you'd be entitled to treat your leave of absence as a termination and go after your severance. All right. So the first thing to accept, though, is that you're walking away from your job. You're saying, listen, this is unacceptable. There's no job for me left. Pay me my severance. But you can't have it both ways to say, well, I'm wanting to continue this employment relationship in the sense that I will stay on leave and you can call me back whenever, and I want to go after severance. You have to choose one or the other. Either you stay on leave and wait till you're called back, or you go after your severance, in which case the job is over. So that's the decision you have to make. Randolph Butternubs asks, what sort of severance am I entitled to if I'm on long-time seasonal worker for an events company? They have recently changed procedures and won't be hiring back my position for the season. So a great way to figure out what your entitlements are, Randolph, is to visit pocketemploymentlawyers.ca. Pocketemploymentlawyers.ca allows you to answer 4 easy questions and figure out what kind of severance you're entitled to. So length of service, I will grant you, is the most important of the 4 factors. But things like your age, the kind of job that you did, what the industry that you work in looks like now in terms of hiring, in terms of slowdown, those are also important factors that will have an impact on your severance entitlements. So if your position that you were being called back to every year has been eliminated, it's very likely that you're entitled to severance now. Absolutely. So visit pocketemploymentlawyer.ca. If you do decide after having punched in your information and gotten your amount of severance back that you want to speak with us, it's very easy to do that right on the page. And then we'll be happy to talk to you about how we can get you your severance. Susanna asks, I gave 2-week notice, but was given to sign a resignation letter that I said quit without notice and was told it was my last day and to leave the premise. What do you think of my case? All right. So firstly, if you're about to end your relationship with your employer, either through a resignation, through a termination, whatever it is, and you're being asked to sign something, it's important that you have that reviewed by a lawyer. Asking a lawyer afterwards what he or she thinks about you having signed is complicating matters tremendously. Part of what you're usually asked to sign is a promise that you'll never sue them for anything ever again. So if you sign that, it makes it a lot harder for you and for a lawyer to go after yourself. So it's very important before you sign anything that you consult with us. That said, Susanna, essentially, you're entitled to the 2 weeks of notice you would have provided. Essentially, what happens is you say, I'm going to quit in 2 weeks. They say, well, no, we're going to terminate you today. You've just lost 2 weeks of wages. All right. You're required to give 2 weeks notice, but you are entitled to be paid during that 2 weeks. So your recourse is to go after the employer for that 2 weeks that you were provided for at when you gave your notice. All right, so that's your entitlement, 2 weeks of severance. You can enforce that. If you're in Alberta, you can enforce that directly with the Ministry of Labor, or you can contact us. We can help you get that entitlement. Ariel Lazaretto asks, my wife of 13 years has been working for certain years. She requested 3 months time off to go back home, but her boss didn't accept that can she treat that as a constructive dismissal and pursue severance? It depends why she wants to go back home. So what I'm understanding here, Ariel, is that your wife family, I guess, is outside of the area where you live, either in another province or another country. And your wife was asking for 3 months to go visit them. If that's what I'm understanding, that's basically asking for a 3 months vacation, unpaid vacation. There's no real entitlement to do that. under the law. All right, your employer can allow you to do that. You can come to agreement with your employer saying, okay, we're going to take some sort of sabbatical, some sort of unpaid leave of absence so you can go visit your family. But there's no requirement to do that. All right. There could potentially be, if there was, a situation where, your mother's parents or a sibling was dying or something like that, gravely ill, there might be some leaves that would be available to your wife. And if the employer refuses that, then that could be a constructive dismissal. Yes. But just a family visit, that might not be enough unless really your wife has the banked vacation. You can't just leave your employer for an extended period of time and expect your employer to hold the job. So that's not necessarily an option. We're running out of time. Thank you all for your very interesting questions today, some very interesting topics. I note that I'm always happy to talk about termination clauses. We also have a lot of information on termination clauses on our website. We're at pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca is one of our websites. Employmentlawyer.ca is our website, our blog, where we have a lot of information about employment law. We have another show coming tomorrow and a show every day this week. So if I didn't get around to your question today, feel free to tune in tomorrow. We'll get those questions answered for you. All right. So thanks for joining us today. My name again is Lluc Cerda, I'm Managing Associate of our Calgary office of Samfiru Tumarkin. We have offices in 3 provinces. Feel free to reach out to you and to us today, and thanks for joining.